The amendment, it's when a relevant person applies under sections 11 and 12 for information, and or when a relevant person applies for their personal data, the relevant body or authority will make available all medical records to the relevant person, regardless of whether they've explicitly requested those items. This amendment is important to ensure that all medical records are made available to a relevant person. A key theme of the pre-legislative scrutiny was that relevant people would be empowered to access as much of their information as possible. As currently worded, the bill may be interpreted by the Adoption Authority of Ireland, TUSLA or other bodies to only provide information explicitly sought, rather than all information, which in the case of medical records may have incredibly important details for the person's health. Given the draconian approach of state bodies and other entities to releasing information, it is necessary that the bill includes this type of explicit obligation. There is a well-founded distrust of the state on these matters, and in particular of the Adoption Authority of Ireland and TUSLA. As legislators, we need to absolutely guarantee that no one will be denied access to their information, nor will it be just withheld without it being denied. When discussing this at committee, the Minister presented the spurious argument that this amendment seeks to force medical people on people who have not requested it. Nowhere, at any stage, did any group or stakeholder even raise the prospect that they'd ever be concerned at receiving too much information. Each and every affected person are continuing to fight for access to information. This amendment provides some assurances regarding their medical information.
In terms of the amendment from Deputy Carnes, and look, this was one we did debate extensively about whether relevant persons, people seeking this legislation, should be given all information irrespective of whether they apply for it or whether they have a choice in terms of making an application. And as we've made very clear, someone will be able to tick a box and apply for all information. But we've also made clear that people can select which types of information they wish to receive. And I think it's a good thing that we give people agency over their determination about what information they receive. There may be, and I don't know what those reasons are, but there may be a reason why someone doesn't wish to receive medical information. Maybe there's something in there, something about their history that they don't want to know. And I think if they wish to make that choice, that's a choice that they should make, and the legislation shouldn't constrain them or compel them to receive information that they may not wish. Absolutely, you're right, that wasn't an issue that came up in pre-leg, but we have to recognise that there is a very substantial number of survivors in this area, and different survivors, as we all know from our engagements, have different views. So I think leaving the legislation as it is and giving people choice on that matter is the best way to proceed.
Corla, yeah, Amendment 15 ensures the bill includes the broadest possible definition of personal data. This comes back to guaranteeing beyond a shadow of a doubt that adopted people and their relatives will be entitled to access information. Given the manner in which this access has been denied and continues to be, and the levels of distrust in how this bill will be interpreted by state bodies, then I think we're obliged to include extensive and really explicit definitions of information relating to adopting and care arrangements. There cannot be any ambiguity at this time. State bodies, institutions and the Church need to have no room whatsoever to continue to deny people access to their information. And Minister, what you referenced there about that you could request, all or just the requested bit of information in the last amendment, if that's to make sense, then when somebody ticks that box for all information pertaining to them, I think we need to go as far as we possibly can in this legislation to ensure that indeed all of that information is provided to them. Because I think the reason why I put in the other amendment as well is that, for example, if you requested information about your parents and that was the only thing you were kind of setting out to look for, if there was potentially information there about you in relation to, for example, an illegal vaccine trial carried out on you or anything like that, that you could find that out then without knowing to ask for that. So if we're to accept that, at that last amendment, you have to pick which one. You either want just what you're requesting or all information. We have to ensure that when you say you want all information, you absolutely get all of that information.
I don't believe that the change being proposed here, I don't believe that furthers that goal. I think it actually restricts that goal because Deputy Funchion spoke about the broadest definition of personal data, but we are providing a definition of personal data, and it is a lengthy one, and I'll talk about its length in a moment, but we are providing a definition that will be in this legislation, and the only way this definition can be changed is if this legislation is amended. Whereas what the legislation currently does is the definition of personal data is defined as the EU defines it. So as Court of Justice cases evolve the definition of personal data, because we're referring to the use of personal data in the GDPR regulation, and that is interpreted by the European Court of Justice. And if they change that definition through their case law, the definition of personal data that we use changes as well. But what this amendment seeks to do is, this is the definition of personal data. This is what we define personal data is for this legislation. And while it is lengthy, it is conclusive. And the only way of changing it is to bring forward amending legislation. So it means that the definition of personal data in this legislation may start to diverge from the most up-to-date interpretation of personal data as per decisions of the European Court of Justice. And I don't think that's a position we want to be in. We don't want to see Irish law start to diverge from European Court of Justice jurisprudence, particularly when it comes to a definition of personal data that is central to what the GDPR is all about. So that's why I am opposing this amendment, and I don't believe this particular change should be made. Now, as I said, it's a lengthy definition. It has 46 different sections, and the vast majority of these are already covered by the definitions contained in this legislation. So the definitions of birth, early life, care, medical information and provided items, that covers the vast majority of those 46 listed types of personal information that is proposed in this amendment. But it is important to say that that list of 46 also contains items of information that is not pertaining to the relevant person. And as Deputy Carn said, this is all about ensuring that information pertaining to the relevant person is available to them. But some of those points are not pertaining to the relevant person. They're pertaining to others. And that's not something that we can include in the definition of personal data. So as I say, we want our definition, the definition we use in this legislation, to be able to expand as the definition from the Court of Justice expands as well. And this would restrict that. And I don't think that's something any of us want to do, so I'll be opposing this amendment.
Deputy Cairns? Yep.
So the amendment is to include, under this Act, all records relating to the adoption or informal care arrangements of a relevant person are considered to be that person's data, regardless of whether the data is shared with another person. Personal data in relation to a relevant person includes, but is not limited to, etc. So the reason that we want that included, and you say, oh, you know, we're better off sticking with things that are the most up to date in line with the EU Court of Justice and GDPR. But the problem is that for like this and previous governments have formed for not having the most open interpretation of GDPR. So the reason that amendment's there is to ensure that that information can be accessed, to try and strengthen that approach that you're talking about, the most up-to-date interpretation of GDPR. That's not the way Ireland has interpreted it so far. So the whole purpose of this amendment is to ensure that finally that actually happens.
Okay, Minister.
Thanks, Deputy Kearns. And as we discussed in the committee hearings, we now have these very broad definitions of categories set out in legislation that TUSLA, the Adoption Authority, other bodies have to comply with. That's now a legislative obligation that was never on them before. We also have in this legislation the power to draw up ministerial guidelines in terms of the implementation of those interpretations. And if it is seen that a body is seeking to implement them in a restrictive way, a minister can write guidelines to make it very clear, no, that's not the way you do it. This is the direction in which you implement. And finally, as you know, we have our implementation group where officials in my department are engaged directly, again with TUSLA and the Adoption Authority of Ireland, in terms of making that culture change that I think we all recognise is necessary in these institutions. So we're using the most up-to-date definition of personal data as it is defined in the linked to the GDPR directive and as defined by the European Court of Justice. We have the very extensive categories of information that relevant bodies must release information to. We have the ability to write and clarify guidelines as we go ahead, and we have the ability to engage directly with the agencies through the implementation body. So I believe that those 4 measures will enable us to ensure that the spirit of openness, the spirit of release that we spoke about at the start of this section is maintained.
Thank you. I've just lost. Yes, you can, as the proposer. Yeah. Yeah.
Just, Minister, in relation to that, you speak about the need for a culture change in terms of releasing information to adopted people, because we all know about our history of that really not happening and the kind of trying to keep it away and keep it under the carpet. And then you say that your department would be tasked with, you know, not only within the department, I suppose, but also within, you know, organisations like TUSLA and the Adoption Authority, with trying to change that culture. I just don't know on what planet it makes sense to task the very organisation that has potentially created that culture with trying to change it. It's just not a practical approach to affecting the kind of change that you're talking about. The very institution that has created a culture is bound to have an inherent aversion to changing that. And I just think it's really important to note that if we need a change in culture, you don't ask the institutions that have that culture problem to implement that change.
Come on. Nobody else? Yep.
Well, fundamentally, Deputy, my department and my officials have engaged in a huge amount of work to bring about that culture change, as demonstrated by this very substantial piece of legislation that we have worked on, that we have prioritised to bring about those changes. And we have seen, and I believe there is a culture change beginning in those organisations. And, you know, if you don't take my view, you know, as a committee member, bring in Bernard Gloucester, bring in the Chief Executive of the Adoption Authority of Ireland, have that engagement with them. I am extremely confident that those bodies are changing, that they see the need, and I believe they actually will see themselves empowered by this legislation to change their approach to the release of information to people who are adopted, to people who are the subject of illegal birth registrations. Change has to begin somewhere. I believe we are beginning it in our department. And I think when you look at our approach to subject access requests, if we're talking about my department, over 500 people have received information from the archive of the Commission of Investigation following on from subject access requests. An issue came up about the release of medical information. We looked for a workaround, but we brought in amending regulations that have addressed that issue. So now there's no question of going to a GP. We brought in regulations to do that. We could have held off because that's dealt with in this legislation, but the principle of the barrier that that statutory instrument from 1989 caused was offensive, and it had to go, and we did change it. So I believe there is a culture change, and it's culture change exhibited in government, a culture change that is feeding through the agencies involved. But it will be up to all of us, those in government, those in opposition, to police that and make sure that that is being delivered on.
So at this point, the question is that the amendment be made. Has the amendment been pushed? Pressed, okay. So the chakti atá hív na ceiste obrigí tá, the chakti atá na gwine obrigí níl. Is the hogabil an ceist culture. The amendment has been lost.